and welcome to the Federal webinar. I am S. Srinivasan. Since independence, the role of governors in India has been a controversial subject. The governors nominated by the center seem to be constantly at odds with the elected chief ministers of the state they are supposed to govern. In states where a party is in power, is politically and ideologically opposed to the party at the center, it would appear almost as if the two sides are at war. The acrimony has now reached unimaginable proportions. The conflict is no longer behind the doors. It is played out in the social media. Recently, the Chief Minister of West Bengal, Ms. Mamata Banerjee, blocked her governor Jagdeep Dhankar on Twitter, saying she was disturbed by his regular Twitter posts criticizing her government. Last year, when post-poll violence had broken out in West Bengal, the governor had expressed his dismay over Trinamool Congress's silence. He had then said that the state was witnessing the worst violence since independence. The new government retaliated, saying his claims were not consistent with real facts. In Kerala and Rajasthan, the respective chief ministers had complained that the governor was delaying the request for convening a session of the state assembly. In the case of Kerala, the government was keen to get a resolution passed in the assembly against the now defunct three farm bills. In Rajasthan, the governor was oddly coming in the way of the CM's attempts at seeking a confidence vote in the House. Karnataka, Maharashtra, and Goa had witnessed different kinds of wrangling over government formation. All the three states had seen unusual scenes being played out inside and outside the assemblies. In Tamil Nadu, the DMK-ruled government was sniffed over undue delay in governor's decision over a bill that sought exemption from NEET, which is mandatory for seeking admission in medical colleges. In India, governors are appointed by the president on the advice of the Union Cabinet, read the Prime Minister. The governor forms part of a state's executive along with Chief Minister, his Council of Ministers, and the Advocate General. He is supposed to act on the advice of the state cabinet. Governor is supposed to be the custodian of the Constitution. Since we follow the Westminster model of governance, real power vests in the elected government, and the governor is just a nominal head. He reigns, but does not rule. But that's where the differences crop up in the way it is seen. In the past, the bitterness between the states and the governors have been largely over dismissal of the government, the selection of a party to form a government, and the deadline for proving majority in the House. Lately, there are complaints of governors sitting on bills and passing negative remarks on state administration. The litany of complaints is only growing. So is there a solution? Recently, former bureaucrat and author Madhav Godbole, in his book, advocated scrapping of the governor's post. Reacting to that, N.N. Vora, former governor of Jammu and Kashmir, had said that, and I quote, Pardon me on this particular quote. This is not particularly against any particular governor. I'm just quoting it. This wretched fellows need not be noticed much, whether you keep them or send them away because they have reduced the constitutional post. They were like the CCTV of the Constitution, now reduced to party posts, unquote. TDP's Chandrababu Naidu has called governors as spies and agents of the union government. CPM leader Sitaram Yechury had questioned the need for such posts in independent India. But on the other hand, several inquiry commissions that went over the role of a governor had recommended its continuation. Though in the past, prime ministers like Jawaharlal Nehru, Indira Gandhi, Rajiv Gandhi, and now, presently, Narendra Modi is enjoying overwhelming majority in the parliament, none of them have made any move against the office of the governor. Therefore, today's topic, should the post of governor be scrapped? Let's discuss. I have with me a former governor, Tathagat Roy, who was for 3 years between 2015 and 2018 the governor of Tripura. And later he became the governor of Meghalaya for 2 years till his term ended in 2020. Not new to controversies, he has been an active office bearer of BJP in those days when the party was little known in the left-dominated West Bengal. I have also with me TKS Elangovan, Member of Parliament. He is a prominent face and voice of DMK, the ruling party in Tamil Nadu. An excellent communicator. He is currently member of the Rajya Sabha. He had earlier represented Chennai North in the Lok Sabha. I welcome Mr. M.B. Rajesh, Speaker of the Kerala Assembly, an active politician from his student life. He is now a first-term MLA. But he's not new to parliamentary procedures and practices, as he had represented Palakkad in the Lok Sabha as an elected member of CPM for over a decade. And he has pushed through various bills and participated in various debates in the parliament. I have also with me PDT Achari, former Secretary General of the Lok Sabha. With his decades of experience in guiding smooth functioning of the lower house, he brings a nuanced understanding of the constitutional niceties and parliamentary proceedings. I have finally with me Garga Chatterjee, head of Bangla Pokho, a pro-Bengali organization. It is organized on linguistic lines. The objective of the organization is to protect Bengali culture. I now welcome all the guests, and I'm grateful to all of you that you took your busy schedule and agreed to attend this webinar. I begin with the speaker. He's a current speaker of Kerala Assembly, Mr. M.B. Rajesh. The house rule is very simple. Each guest is given about 4 minutes to make his presentation on the motion, followed which we'll do a discussion. Mr. Rajesh, welcome. Hello. Can you hear me?
Rajesh, unmute.
Unmute.
You are in mute position, Rajesh.
Thank you, Mr. Srinivasan. And I'm very delighted to see Mr. T.K. Salangovan, my old friend and former colleague in Parliament, and Mr. P.D.T. Ajari, who was a Secretary General of Lok Sabha when I was a Member of Parliament. And I would like to convey my greetings to all my fellow panelists. Srinivasan, you have rightly explained the context in which this webinar is being conducted. A number of states have witnessed, and they are witnessing on a day-to-day basis conflicts between governors and elected state governments. Though these conflicts have increased in the recent past, this is not an entirely new trend. This conflict has a long history in independent India, right from the dismissal of first democratically elected communist government headed by Comrade E.M.S. Namboodiripad in Kerala, to the recent developments happening in Bengal, Maharashtra, and elsewhere. Why these unending conflicts between elected state governments and appointed governors? I think that the root of the problem lies at the colonial origin of the governor, of the office of governor. The Constituent Assembly retained the post of governor from the pre-independent Government of India Act of 1935. The purpose of the post in 1935 Act, which established provincial assemblies, was to ensure that the overriding power remained with the British. The Constituent Assembly not only chose to retain the colonial legacy of having an appointed governor, but even vested it with discretionary powers. In the new constitution adopted in 1950, articles dealing with the powers of the governor were almost verbatim reproduction of 1935 Act. There were concerns raised by many members of Constituent Assembly, but all those concerns were brushed aside on 2 grounds. Number 1, dearth of competent legislators. Number 2, certain amount of centralization was necessary in a nascent state such as India. So these were the 2 justifications given for retaining the post of governor in our new constitution. And the expectation at that time was that the government will consult provincial cabinet in the election of governor, and the president may choose a person of undoubtful ability and position in public life. This was the expectation. Alladi Krishna Swami Iyer has expressed this expectation in Constituent Assembly. But the experience in the last 75 years have seen the contrary. That expectations have not come true. Instead, there has been departure from the conventions. Nehru talked of 3 conventions. Number 1, governors will be appointed only on merit. Number 2, chief ministers of the concerned state will be consulted. Number 3, that appointment of only person from outside the state. But the practice of consulting with the chief ministers of the concerned state was later abandoned. And the experiences shows that the post of governor, as apprehended by many members of our Constituent Assembly, has been widely misused for political purposes. The central government is appointing the governor, and the loyalty of the governor is to the appointing authority. And the governor acting at many instances, a number of instances we can cite. Governor is acting as an agent of the central government. So this has led to friction in the center-state relations. This has posed serious challenges to our federal polity and popular democracy. I don't want to go into details. So I will conclude in just 1 minute.
Right.
It is to be noted that no major countries having a federal constitution does have a provision for appointment of governors by the central government. It is high time to rethink the necessity of this post, the root of which lies with the colonial rule. Soli Swarabji, eminent jurist, once said that the governor at the time of British rule was an autocrat, was like a dictator. So we are retaining that post with almost the same powers even today, even after 75 years of independence. So I think that this is high time to rethink the necessity of retaining that post. If at all that post is to be retained, the appointment should be made in the manner recommended by Sarkaria Commission. Sarkaria Commission recommended that there should be consultation with the chief minister concerned. The chief minister can propose 3 names of eminent person, and the president can choose from that panel. So that was the recommendation of the Sarkaria Commission. Interstate Council has discussed these proposals time and again. So I think that this is high time to discuss whether we need to continue with the post of governor.
Right.
Thank you.
Thank you. Thank you very much for your opening remarks. I think it really sets the tone. I'll now go to Mr. Elangovan. You can make your point.
Yes, sir. Thank you, sir, Mr. Srinivasan. I agree with what Mr. M.B. Rajesh had said. The problem here is, during the British rule, it was diarchy wherein some of the powers were vested with the elected legislature and many of the powers were vested with the British government. So they wanted a governor to rule on behalf of them. And a elected government here, a first minister and other ministers, to rule, to decide on the powers vested with them. So the entire government, the entire powers of the state government was not vested with the elected government. That is called diarchy. That is two governments. That is the meaning of diarchy. So at that time, the role of the governor was different. He decided on matters which were vested with the Queen, with the British government, British throne. And here there was a government which decided on certain matters. That is one thing. Secondly, in the US, you have governors elected by the state, people of the state. Here, the only constitutional post, a politically important post, which was done by appointment, is the governor. Because even the president was elected by the elected legislature and the members of elected legislature and the members of parliament. The only post which is a go by the advice of the cabinet. Am I audible?
Yes. I think we have got you back. You briefly unaudible. Now
Is
it's
there any
fine. Yeah.
problem?
No. Please go on.
It's okay.
Yeah. Please continue.
That is the problem. Here, one more thing. During the debate, it was clearly stated that a governor cannot be a replacement for the elected government. One thing. If there is no elected government, he can administer the state, but he cannot take any policy decisions with regard to the state administration. But what had happened in Kashmir, when the assembly was not there, it was dissolved. The government said that the governor is ruling the state. So he is an alternative to the assembly. So on his recommendation, we withdraw Article 370. See how the post of the governor, the powers of the governor is being misused by the center, the union government, is the question. Secondly, here in Tamil Nadu, we have a peculiar, the assembly passed a bill and sent it to the governor. The governor has the power to return the bill. There is no doubt that the governor can return the bill for constitutional reasons. But what the governor stated in his statement, the Raj Bhavan release, was that for political reasons, he had returned the bill. The governor has no say on that. He can only return the bill if it is against the constitution or if it violates any of the existing laws of the state. But the governor kept the bill without sending it to the president for about more than 6 months and then returned the bill stating that this bill is not this bill is not in the interest of the people. See, that is not his role. That is not the reason which he can say. But he did that. So everywhere in Delhi, there is a problem. And we have seen here, Honorable Speaker is there. See, any parliament session or assembly session, the governor will convene the session and prorogue the session. In between, the speaker will call for the meeting and adjourn the meeting sine die, after which the governor will prorogue the session. But the governor tweeted that using the powers the constitution has provided with him, he is proroguing the session, as if implying that he has the power to prorogue the session, close the assembly. That nowhere I have seen for the past, during all these 74 years of independence.
Yeah, I think to be fair to him,
Governor
this was
say,
clarified later. This was clarified later that it
yes.
was
No, but
in
the Twitter is
yeah,
one thing. I'm talking about not the
right,
notice
right.
sent to the government or a statement. I normally feel that governor, the all people holding high office should not use this social media for explaining things. They have to give a press release so that it reaches out to everybody. Social media will reach out to only a select group of people. So the governor using social media has created all problems.
Yes.
So the post of governor, see what is their rule is nothing. They have to send the bill to the president or they have to return. There is a chief justice. The chief justice can prefer oath of office to the cabinet ministers. Okay. Then what else is the role of the governor? Only when there is no assembly, the governor will administer the state. And even then, he will have some senior officials as advisors. If the center wants to have an administrator here, they can use senior IAS officials as administrators for a short period when there is no assembly. But the governors are misusing their powers because of the only reason, because of the single reason that they were appointed by a party which has a different political view, a different political party than the one which is ruling the state.
Yeah.
They are misusing the power.
Yeah.
That is,
Thank you. Yeah. Thank you. I'll
so
take this.
post
Yeah.
of governor is a waste of. Like, we can easily dispense with the post of governor. That is my view.
Right. So we'll come later to what should be the alternative. That we'll discuss. Meanwhile, I'll go to uh, so we have the initial remarks. Now I'll go to Garga Chatterjee so that we hear all of you. Then we can go to Achari for seeking his opinion on what does he think from a constitutional point of view. Garga, please.
Namaskar. So, the Indian Union is a democratic republic, as we know. So, democracy is important. Republican values are important. And also, it's a federal republic because federal structure is a basic part of the basic structure. So, Republican values have to be upheld both at the union and state level. What do I mean by that? It means that people's representatives rule the union and the state. That as simple as that. It's only people's representatives. Nobody except who are not people's representatives can rule a state or the union for that matter. Now, people can argue when it comes to the question of the governor, and I'll come, that the governor essentially is nominated or appointed by the president, who is elected indirectly, who are also elected. So one can actually come up with a chain of, let's say, representation, right? But this is not direct. So the rule has to happen through people who are directly elected. Having said that, let us go very briefly into the colonial origins of this governor post. And that is very important because coming from Bangla, we know that what British rule did to us and of course to the Indian subcontinent at large. In 1770, 1/3 of our population was wiped off. In 1943, 60 lakh people got wiped off with certain local, Birla Ispahani type of collaborators. But we have really felt the brunt of British rule. We have been destroyed. People say, when you go around the governor's palace area in Kolkata, people say there is so much sign of British rule in Kolkata and Bengal. I would like to say that there are far more signs of loot of Bengal in Britain. Their small villages have become towns due to Bengal's money. Having said that, the pushback against British imperialism has had a long history. And after the 1935 Government of India Act, the British tried to retreat to the so-called center. The whole process was self-rule, 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 home rule, Swaraj. It came by various names. And the large part of what we call self-rule or Swaraj, by 1935 Government of India Act and through the provincial elections of 1937, was that at the provincial level, autonomy was given. Basically, natives run the place for certain subjects, which we basically have bequeathed as the state list. Now, what is there in the mentality of the British, a colonial power, extracting power, an anti-native power, to continue having a post akin to a governor and having something called Section 93 in the Government of India Act? It means, it's an old British saying, an old colonial saying, that the natives cannot be trusted with their own affairs. You know, that natives are like children, while people sitting in imperial centers are mature, are kind of, they have a better understanding of things. You know, we are little people, those are big people. And little people can go wrong and things should not be left to them. And there should be provisions for kind of with a stick to hit them when they are not in line with imperial interests. So you have Section 93, whose post 1947, or rather post 1950 version is called Article 356. It's a terrible idea that a person who is not elected can displace a government which is elected and rule in lieu of them. As Mr. M.B. Rajesh said, that dearth of competent legislatures, that was one of the logic in the Constituent Assembly, that is basically saying the same as natives cannot rule themselves. It's another way of saying the same thing, that natives are not competent. Natives have always been competent. It is the competency of the natives which have pushed out the British, competency of the natives in resisting imperialism. And imperialism has nothing to do with color. It is the nature of the structural control of people's resources, of people's own rights, of devolution of rights. If that is being controlled, that is essentially imperialism in its, you can call it a new bottle.
Right.
So very briefly, Bengal, for example, its history could have been different. For example, in the 1937 elections, when the Congress party, which emerged as the largest party in the legislature, but not the majority party, and the Krishak Praja party, they wanted to do an alliance. It's an interesting part of our history. The sticking point was that the Krishak Praja party had certain other priorities and the Congress had certain other priorities. But they agreed on all of them, but which would be dealt with first. For example, Congress insisted on that liberation, that the people who are incarcerated, the freedom fighters, they should be set free. The problem was that if that was insisted upon as action item number 1, then Section 93 could have been invoked and the government could have been removed. And the other party, the Krishak Praja party, would not be able to carry through its part of the promises, whatever it had made to its constituents. Hence, a very historic thing didn't happen. Something could have averted the partition of India.
Right. Yeah.
Just very briefly.
If you can, quickly come so that we can.
Very quickly. So Bengal has been subject to this post-partition. The first non-Congress government has been scrapped, and typically all these faults about governance and law and order and this and that are typically found with opposition party governments, and that tells you that there's a partisan scenario. Right. These are all evolving into union and state versus issues. The NEET issue with R.N. Ravi is a very important thing. And in future, as people are talking about redistribution of seats along to latest population figures, we fear that the governor's role, the governor's office may also be abused for Hindi majoritarian rule.
Right. So I think we'll come back. I think now you're getting into other areas. I've heard your thing. If you have anything particular to say about the post of the governor, whether it needs to be retained as it is in the current form, or it needs some amendment, or you are completely, like other speakers are saying that, time has come to replace it, or the post itself. You can think of it.
In a Republican setting, there is no place for a governor.
Right. Thank you. I think we'll come back to hear more of you in the second round. Now, I want to go to Mr. P.D.T. Acharya. Acharya, if you can tell us, constitutionally, I think there is some confusion here also. Neither we are, we are a union of states, but with a federal structure, even there is a certain thing. And also, you refer to the governor role in Kashmir also. Can you just, clarify these issues? I think you're muted. Please unmute. No.
It's in the lower left side, Mr. Acharya.
Is it unmuted?
Yes. Now we can hear you. Please go on.
Yeah, can I seek a small clarification from you, Srinivasan?
Yes.
This is, in this round, we have to speak for about 3-4 minutes.
Yeah. Speak about 4 minutes.
Basically about the question that has been posed, I think.
Yeah.
And we will speak
in
detail.
You have heard others also. In case you want to respond, you can respond also.
Okay. Now, thank you, Srinivasan, for giving me this opportunity. I have been very keenly listening to the distinguished panelists who spoke before me. In fact, I will come straight to the question that has been posed in your webinar, that is, should the governor's post be scrapped? I will deal with this question in detail later, in the second round, perhaps, when the discussion on the subject takes place. So by way of initial remarks, I would like to say that this is a demand which was raised by the political parties on the left, some years ago. They were making a very strident demand that the post of the governor should be scrapped because they thought that the governor was interfering in the state administration, and it was acting as an agent, and then it gives wrong kind of reports to the president, and ultimately, the governments are dismissed, and so on and so forth. But we have retained the governor's post, and at no time was any serious effort made by the central government to scrap this post of governor. Now, if you go through the Constituent Assembly debates, a mention has been made by the Honorable Speaker, Sri M.B. Rajesh, and also Mr. T.S. Langovan, and the other distinguished panelists, Mr. Chatterjee. Actually, there, different voices were heard, but I was struck by one particular point of view, and that was of Dr. Ambedkar. He was in favor of not only retaining the governor's post, but he was also in favor of giving a certain discretionary powers to the governor, because he felt that in India, a post of governor should be there, and the governor's post is necessary because of the peculiar situation that was prevailing in India. And the states are in a subordinate position so far as the union is concerned. And it is the interest of the union to keep the states under some control. And for that purpose, they conceived of the governor's post. Of course, we know that the governor during the British period was all powerful. He was appointed by His Majesty, and he had all the powers. He was a dictator. Although, as many of the distinguished panelists have said, many of those provisions have been bodily lifted from the Government of India Act of 1935 and put in our constitution. If you go through the wording, you would be struck by the similar, the attempt to copy the text of 1935 Government of India Act. So this was the prevalent view in the Constituent Assembly, and that is why the governor's post has been retained, and not only retained, governor has been given some discretionary powers. Apart from that, I feel if you look at Article 355, because 355 says two things. One is that the union has a responsibility to protect a state from external aggression and internal disturbance. That is one part of it. The second part is to make sure that the administration of the state is carried on in accordance with the provisions of the Constitution. Now, I feel that the need to have a governor flows from this article, particularly the second part of this article, where it is the responsibility of the central government to ensure that the administration of the state is carried on in accordance with the Constitution. Now, so the Constitution itself envisages a governor. Perhaps the Constitution itself speaks about the justification for having a governor. But at the same time, we cannot shut our eyes to the criticism that is being voiced against a certain misuse which the governors indulge in, or certain activities of the governors, which have been committed upon in the country very extensively at different points of time. Now, that needs to be certainly looked into seriously. And what I feel is there has to be some criteria have to be laid down. Of course, Sarkaria Commission's report has been mentioned, but some criteria have to be laid down for the appointment of governors. And I personally feel that the politicians should not be appointed governors. Governor should be an eminent person from other fields and not from politics, because the danger is once a politician, always a politician. And normally it is the retired politicians who are appointed as governors. But unfortunately, Raj Bhavans have become an extension of their political life, and therefore they start playing politics. And we have seen that happening in different states, particularly at this time. Therefore, to check that, we should not have politicians, because all other things are being controlled by politicians. So why not the governor supposed to be given to somebody else? That, I think, I should end here. These are my initial remarks, but later I will speak in detail about the constitutional provisions and all that later.
Right. I have a number of questions. I think let's hear the governor. He is the one who's actually been in the hot seat. So let's hear him, and then I'll come back. Mr. Tathagata. Sir. Right. I think, please.
Thank you very much, Mr. Srinivasan, and my greetings to my fellow panelists for having invited me to this debate on a very topical and very important question. You see, at the outset, because I have had the advantage of listening to the different speakers before me, at the outset, let me correct a few things according to my perception. It is not to be taken as a kind of attempted correction, so to say, but factual points on which I have differed with the previous speakers. Say, for instance, when the speaker, Honorable Sri M.B. Rajesh, has likened the governor to the governor of the British rule under under the Government of India 1935. I think that is a misplaced comparison, because we have brought about a lot of departure. The Constituent Assembly had brought about a lot of departure from the provisions of the Government of India Act 1935, which is why we needed a constitution. Otherwise, we could have jolly well carried on with the Government of India Act 1935. In fact, the drafting committee of the Constitution, which was chaired upon by Dr. B.R. Ambedkar, a very, very remarkable and knowledgeable personality, he had retained in the draft Constitution the institution of the governor. And surprisingly, so far as I have read the Constituent Assembly debates, there has not been any debate on the institution of the governor as such, or rather the question whether there should be a governor or not. There had been some debate on the question whether a governor should be elected or he should be appointed, as is the case presently now. Now, the second thing that I would like to emphasize in regard to what the Honorable Speaker, Mr. Rajesh said, that consultation with the state government before appointment of the governor, this I am assured it still holds, because after I had been sworn in as governor of Tripura, I had paid a visit to the then Home Minister Rajnath Singh, and he had told that he had consulted the chief minister then, who belongs to the CPIM, and the chief minister had consultation. Of course, does not mean concurrence. But the chief minister then, Mr. Manik Sarkar, he had no difficulty about appointing me, and therefore I was appointed and I was sent forth and I was sworn in as the governor of Tripura. It's a small state, but it's peculiar and important in certain ways. We'll not go into that. But there is another point that the Speaker of the Kerala Assembly made. I would like to very respectfully correct that no country with a federal structure, has this kind of arrangement whereby the central government appoints a governor. With respect, there is such a system in Canada, which is one of the constitutions on which our drafting committee based their initial draft. In Canada, the Governor General, who is appointed by the Queen, of course, on the British sovereign, on the advice of the cabinet, the Governor General appoints the provincial lieutenant governors. They are called lieutenant governors. And this lieutenant governor, in the appointment of the lieutenant governors, he is not constitutionally obliged. The Governor General is not constitutionally obliged to consult the cabinets of the different provinces. Now, Mr. Elangovan had spoken about diarchy. I very respectfully said that diarchy was given a goodbye in the 1935 Act. Diarchy is a thing which is a creature of the 1919 Montagu-Chelmsford reforms, whereby diarchy was introduced. The 1935 Act was a quantum jump, but of course, subject to the British sovereignty. Now that brings me to the arguments advanced by Mr. Garga Chatterjee. I am rather disturbed at the manner in which he has likened the states to natives and the center to the British, that the state or the natives cannot be trusted to run their business in their proper manner, and therefore have to be subjected to the whims and fancies of the superior authority, which is the center. Now, with great respect, this is absolutely not so, because the center didn't descend from either England or Mars. The center, the government which is ruling at the center, is completely a creature of the people. The people of the country have chosen a particular set of people or a particular party to govern at the center, and therefore it is specious to liken the state to natives and the center to an imperial power. Also, there is the question of the unitary slant of the Constitution, which is has been mentioned by him as some kind of hangover of imperialism. this unitary slant of the constitution in spite of there being a federal structure. The unitary slant, for instance, is typified in the fact that in India, the restitutory power state rests with the center. And the concurrent list, in respect to the concurrent list, if there is any kind of conflict between a central legislation and a state legislation, the central legislation prevails. These are not products of imperialism. These are the products of Indian brains who had pored over the question and debated them with great deliberation and had come to the conclusion that this is the way in which a country like India should be governed. Now, as for Sri P.D.T. Acharya, I have to confess that I have nothing to add to him. Whatever he has said is absolutely right. And the point that I would absolutely like to emphasize with all the power at my command is that Article 355 is to be very carefully looked at. Article 355 is practically the fountainhead of the institution of the governor. The Article 355 says that it shall be the duty of the union to protect every state. I am reading verbatim. It shall be the duty of the union to protect every state against external aggression and internal disturbances, and to ensure that the government of every state is carried on in accordance with the provisions of this constitution. Now, so long as you hold the constitution as sacrosanct and the constitution as what is called suprema lex, the supreme law, so long as you do that, this Article 355 confers on the state government the duty that I have just now mentioned. Now, how is the central government chosen by the people going to discharge this duty? They can do it only through an appointed person who happens to be the governor. So therefore, however much there may be objections, it is not possible to dispense with the institution of the governor so long as Article 355 is there. And another point that Mr. Gargacharya tried to make, I will very briefly try to mention it. He had said that at the very beginning that nobody other than people's representatives can rule the country. Nobody other than people's representatives. Begging his pardon, that is not so. The constitution prevails over the will of the people as expressed through the majority party. Even if the will of the people expressed through the elections in the formation of the majority party is something, the constitution will prevail over this. And this was emphasized by the Honorable Supreme Court, a 5-judge bench of the Honorable Supreme Court in the case of B.R. Kapoor versus the state of Tamil Nadu. So, and the constitution is what the Supreme Court makes of it. It is not anybody's political opinion that the constitution is, that makes the constitution.
Right. I think
I'm about to conclude. Give me just another 30 seconds. So all these things lead us to the conclusion that however much a party which differs politically with the party at the center, both parties, both governments having been elected by the people, however much this difference may be there, having an institution like the governor is inevitable and has to be there so long as Article 355 is there. Thank you.
Right. Thank you very much. I think we have heard all of, and I think Governor Tathagata spent a lot of time actually answering the questions which others have raised. But I have a few points here. I think Garga wasn't actually trying to suggest that, just a correction, we'll go on to the other question. He was just saying that native versus British is what those days, I think he was talking in the past context. I don't think he's saying it in the present one. I don't think he meant it right now. I don't think so. I think that's what I understood. The point which, the other point is, I think that's what I want Mr. Acharya to say, but even, the speaker, honorable speaker can also say that if he wants to clarify. There is still this thing between a federal structure and a unitary one. this keeps on coming. See, what Ambedkar and others probably said in the past was that we need a very strong center, and that is essential for holding India as a nation together. And those were the wisdom which was expressed then, and therefore the need for keeping such a structure. But we are still called a union of states, but it is also federal in nature. So have we now come over after 70 years of more than 70 years of independence, have reached a stage where we need to reconsider these issues, that it needs to be more cooperative federalism between the state and the center. And, is that equation also need to relook? Acharya.
See, India is called a federal country with very strong unitary features. India is called a federal country because of basically the division of legislative power between the union and the states. As you know that we have three legislative lists: the state list, the union list, and the concurrent list. So the entire legislative power of the state has been divided between the union and the states. And that is the main or fundamental feature of a federal system. But at the same time, as everybody knows, we don't have, our federal system is not like the American federal system. There is a radical difference between these two systems. Right. And that is because of the peculiar situation in which India was placed at the time of independence. We have seen, there were many problems, serious problems, which the government was facing. And those problems were such that even the very existence of India as a free nation was almost in danger. So naturally, the constitution makers were quite aware of that. And therefore, they wanted the union to be strong so that the country can held together, as you said just now. So that is why the unitary features have come in such a big way. There are many, many provisions in the constitution which emphasize the importance of unitary features of this constitution. Now, the first, of course, it has been referred to earlier, is that whenever there is a breakdown of a constitutional machinery in a particular state, then the union takes over, the president takes over the administration of that state to ensure that the administration of that state is run in accordance with the provisions of the constitution. Now, there are many other provisions in the constitution, as Mr. Tathagat Roy has said, that the residuary legislative power rests with the union, and it doesn't rest with the states as it is the practice in the United States of America. Then we have Article 256 and 257. Article 256 says that the executive power of the state should be used in such a way as to promote, facilitate the implementation of the laws made by Parliament. And the union government, that is more important. The union government can issue directions to the state to ensure that the laws made by Parliament are enforced, implemented without any hindrance. Similarly, Article 257. Article 257 says that the executive power of the state should be so used as not to impede the exercise of the executive power of the union. And the union government can issue directions to the states on this for this purpose also. Now, I will take you to Article 365. Now, what exactly happens if the state refuses to oblige the central government, the union, refuses or defies the direction given by the union? what happens then? That is explained in Article 365, which says that if any state fails to comply with the direction given by the union government, then the president can presume that the constitutional machinery in the state is broken down. Means the administration of the state cannot be carried on in accordance with the constitution. And then what happens? Then Article 356 comes into the picture.
Right. Yeah, please. Yeah, can be quickly, can wrap it up. Yeah.
Yeah. So these are some of the provisions which emphasize the unitary, the importance or the primacy of the unitary features of the Constitution. That is it.
Yeah,
Okay.
but here, the real issue is there are one or 2 points which I would like here to highlight. One point which you said, that selection of a governor, that's a crucial aspect. And the governor made an important point that actually the chief minister was consulted, which is interesting, but I don't know whether it is followed in all the cases diligently. Because if that is followed, I think most of the problems should not occur. But I don't know whether it is followed. But in his case, he certainly says it was followed. That's one issue. I would like to have the views from others also on this. The second question is, you said, if any eminent person other than an active politician. So I think one of the understanding of this also, that instead of an active politician who has still yesterday been, nowadays, even somebody who was a party chief till yesterday, is now appointed as a governor next day. There's no cooling period even. So is that another issue, that where an active politician should not be appointed, and which may not be, it can go as a convention. Is that a second issue? So especially, but it hasn't helped in the case of Tamil Nadu. Right now, you have a non-politician, but they're still seem to be having some kind of a confrontation with him as well. So, Mr. Elangovan, if you can take this point, that if eminent personality from other fields are brought in, maybe that's a solution. Do you agree?
Mr. Srinivasan, can I come in for 30 seconds?
Yeah, sure. Let him say, then you can come back. Yeah.
Okay, fine.
Sure.
See, the post of governor, what we question is not what was quoted by Honorable Governor, that Article 355 is important, and the role of the governor is to ensure that Article 355 is properly carried out. But we are not questioning about all those things. Before Bommai case, even the usage of Article 356 was not questioned. But Bommai case gave a clear ruling on that. After that, Supreme Court had given a clear ruling on that. The question is whether the governor acts according to the Constitution or goes beyond the Constitution. That is the question. What I quoted, when I quoted me particularly,
yes.
I said that the role of the assembly should not be taken by the governor. But there, the governor the central government stated in the parliament that since there is no assembly and the governor is ruling the state, he has the power of the assembly. So we have to have taken the advice of him in scrapping Article 370.
Okay.
Secondly, the role of the governor in the Tamil Nadu case against the resolution against need, he should have forwarded it to the president. He did not do it. He kept it for 6 months without forwarding it to the president and returned to us stating some political reasons, not constitutional reasons. So what we question is that we are not against Article 355. We are not against the duties of the center, but it is the external pressure, external danger and internal disturbance. It is more than that. It is the disturbance from the government of India, the union government's disturbance, for which the governors are
understood. Let's quickly go to the governor. Yeah, Mr. Thakur.
Yes, what Mr. Elangovan said, quite rightly, is that you have no quarrel with Article 355. So long as it is there, I have no quarrel with that question. because in order to give teeth to Article 355, we need the institution of the governor. As for the question that Mr. Srinivasan had raised regarding the consultation, regarding consulting the state government, there is no constitutional provision as such, but I was assured by the then Chief Minister, then Union Home Minister, that he did consult. And although my political views are very well known and they are quite contrary to what were held by the then Chief Minister of Tripura, still the Chief Minister of Tripura did not object to my being posted as the governor there. And I am very happy to report that we had no serious problems. We had no serious problems during my 3 years and a few months more of stay in Tripura. I had more problems in Meghalaya, but that's a different thing. The other question that Mr. Srinivasan raised was that other than appointing other than politicians and persons other than politicians as governors, in principle, it may sound quite all right. But supposing there is a constitutional question, all questions regarding governance have a political aspect. A person who has not had any kind of exposure to politics, would it be possible for him to tackle such a problem with some aplomb, with some tact? That question has also got to be looked at.
Right. I agree with you. Actually, there's need to be a sense of balance between a political person. If he's too political, even that's a problem.
That's right. That is right.
I think the Constitution per se, everywhere, the fact is reasonable. How reasonable? I mean, even the power of discretion also reasonable. The freedom of expression, reasonable, I think. So I think let's hear Mr. Rajesh. You wanted to say something? Yeah. I think you're muted. Please unmute, yeah.
Corner, bottom left corner.
Okay, yeah. May I clarify some of the points raised by Honorable Sri Tathagat Roy ji?
Please do, yeah.
Yes. So he was saying that the post of governor in independent India is not similar to the post of governor under British rule. And that equation was not correct. So let me clarify that that comparison was not made by me. This concern was raised in the Constituent Assembly itself. Let me quote Rohini Kumar Chaudhary, speaking in the Constituent Assembly debates way back on 2nd July 1949. R.K. Chaudhary said, "It seems as if to say that the governor is the same governor, a representative of the British monarch, and as such, the chief minister is subject to him and must carry out his orders." So this was a concern raised by Rohini Kumar Chaudhary in Constituent Assembly. So that was what I was just sharing that concern. So, and the experiences shows that, especially the recent series of events happened in the recent past shows that apprehensions were justified. Secondly, regarding consultation, Honorable Tathagat Roy ji said that before his appointment, the Chief Minister, the then Chief Minister of Tripura, was consulted. I was not referring to, I was not aware whether he was consulted or not. I cannot talk about that. But I was not just referring to a mere consultation. I clearly said that what should be done is that the consultation should be in the manner recommended by Sakaria Commission. The Sakaria Commission has recommended that the Chief Minister may propose 3 names of eminent persons, and the President may choose from this panel. So that is what meant by consultation. Thirdly, Honorable Tathagat Roy ji said Canada is having the same appointment mechanism or appointment procedure as we have in India. There's a lot of difference, huge difference between Canada and India. There is no monarch Queen is not appointing governors in India. It's a elected central government, and there are elected state governments in various states. So the appointment of a central government over and above the state governments. So this is problematic, and I don't want to go into other details. I can have I can share you a lot of data regarding the tenure of governors, how governors have been transferred. All those things are here, but I don't want to go into such details. And regarding that federal and unitary contradiction, India, as constitution, is a federal country, but at the same time, the unitary character is more dominant and strong. Hence, there has been issues, there has been debates and discussion over this, the state rights and the undermining of federal character, etc. In the recent past, this has to be viewed, the issue or the debate of the governor's interference with the state governments has to be viewed in the context of increasing onslaught against federal character and federal rights of state governments. This is not an isolated issue. The issue of governor is not an isolated issue. This should be discussed in the context of increasing assault on federal rights or state rights of state government. Thank you.
Okay. I think I would like to pose this question to Mr. Tathagat. See, the point is, I think the debate is not about Article 355 or 356. I think those issues are post-Bombay as settled, I think, more or less. And we don't see that. But the real issue which they seem to be pointing out, the states have a problem, is administrative interference.
Yeah.
The governors are being accused of trying to take over executive functions, trying to hold administrative meetings, the district magistrate, superintendent of police, elected representatives, so on and so forth. So they have the right to call for information. There is no problem. They can ask for any information. But this seems to be a flashpoint between the governor and the state, where there is a majority elected government. They seem to be having confrontation on this. I think that is the issue which more states are facing now, other than the federal issue. I'll come to that later.
Yeah, that's it.
Yeah.
See, I don't have in-depth knowledge of exactly what is happening in other states. But may I just add my 2 cents on what is happening in my state of West Bengal, which Mr. Garga Chatterjee wrongly refers to as Bangla. The name of the state is West Bengal. In West Bengal, the litany that we have been hearing from the state government is that the governor is not acting constitutional. Whereas the governor is saying that I have merely asked for information and they are not furnishing information. And thereafter, the governor has gone on social media. Now, Mr. Ilangovan, I think it was Mr. Ilangovan who has objected to using of social media. And he has said that the governor ought not to go on social media. He ought to give press releases. With respect, I would say that nowadays the press is kind of on the wane and is gradually being taken over by social media, YouTube and other means. I mean, any journalist would bear me out. So in
I would very strongly differ with that, but we can talk it later.
Would, but we can have a different debate on that.
Yes. Yeah.
But social media is a thing that was not conceived of, that could not have been conceived of in the earlier years, even 10 years, 15 years back. So that being so, there should not be any serious objection to the governor airing his views on social media per se, other than his transgressing his constitutional limits. Dr. Ambedkar had repeatedly said that the governor's post is an ornamental post. He has repeatedly said, when this question was being debated, as to whether the governor's post will be an elected post or an appointed post. He said it's an ornamental post. Why go into the trouble of getting him elected? It is going to cost money, it is going to cost time, and we may not have many contenders for it. So let us have this system of appointment, and the parties agree. I think the question was raised regarding what Mr. Rohini Kumar Chaudhary, a very competent legislator from Assam, had said regarding consultation. But this question was answered. I mean, if the governor uses some kind of his personal discretion in installing the state government. But this question was very adequately answered by Dr. Ambedkar. And we have seen a repetition of this in Maharashtra, that if the governor takes a wrong step and acts according to his personal discretion, the inbuilt mechanism of the constitution will correct him. And thus, Dr. Ambedkar was proved right.
Right. Okay. Thank you. See, the question is, transparency is something, but transparency in governance is something, but settling a difference publicly through social media. Of course, the reach of social media is also a question, which he says, Mr. Elangovan says it doesn't reach everybody. It is only a select urban. I think that's his concern. But is it a fair point to say that, the difference between a constitutional head and an elected head should be out in the open on a kind of turned into a Twitter war? Is that fair? Is that how statecraft is conducted? Is it a good way of conducting a statecraft? I would like to raise this. Who wants to answer this? Anyone who?
I have raised the topic now, so
No,
may I just put in my 2 cents?
Yeah, sure. If anybody wants to say on this, then
Can I say something?
This is a new improvisation. Let us give it a trial.
Okay, fine.
Can I say something on this?
Right. What you're saying is it's something new and let's try out. Okay, that's what you're saying. Okay, yeah. Yeah, Achari.
Actually, the issue that has been raised is very, very, very important, very serious. The kind of tussle that goes on between the governor and the elected government. What exactly are the powers of the governor? In fact, does the governor have any executive power? Although the constitution says that the executive power of the state vests in the governor, which he will exercise either through directly or through officers subordinate to him and all that. These are words, which have been physically lifted from Government of India Act of 1935. But the Supreme Court has, in a catena of cases, settled this question that the governor is a constitutional head who does not enjoy any executive power. The real executive power vests in the elected government, and the governor can act only on the aid and advice of the Council of Ministers.
Right.
Now, this point has been settled for all times to come, because from Shamsher Singh case to Nabam Rabia, this matter has been settled, and it is beyond any doubt now. So, a person who is appointed as a governor, of course, they are all very senior politicians and otherwise eminent men and all that. So they are aware of this constitutional position. They know that the real executive power vests in the government. Of course, as you said, under Article 167, the governor needs to be informed. Well, that is his right. The governor has a right to be informed about the affairs of the government, how the administration is being carried on, and what legislative proposals are coming, and so on and so forth. But otherwise, the real power vests in the executive government. The governor should be aware of these limitations. Of course, there are certain areas where the governor can use his discretion, which are actually specified in the Constitution. Some of them are specified in the Constitution, but some are some have not been specified. For example, appointment of the chief minister and certain other areas. So that is the position. If the governor, whoever is the governor, realizes this, then I think a proper equation can be built and a harmonious relationship can be maintained. But the problem, Mr. Srinivasan, is just one minute.
Right.
The problem, Mr. Srinivasan, is that we have politicized the whole office of the governor. Unfortunately, here, the governor is an appointee of the president. So naturally, the government of India, whichever party runs the government here, thinks that the governor will be acting as the dictates of the central government. President means only the union government. And therefore, whatever the union government wants the governor to do, the governor will have to do it. The governor will be at, permit me to say this, governor will be at the mercy of the union home ministry. If that is so, then the entire constitutional scheme, will be set at naught. That is the problem. That is the problem.
Yeah.
There is nothing wrong with the constitutional provisions, but how he worked the constitutional provision, that is the most serious problem. And that is why all these questions have arisen. It is only political.
Exactly. It's not the constitution per se, but the person who uses that's the question. I think the discretionary powers which you're saying, but there is that if the governors have discretionary powers, but it always need to be used with exercised with caution and in a reasonable manner. I think what you're trying to suggest is the discretion can't be exercised under a directive from Delhi. Is that what you sense, Ilangoman?
No. What I say is how the post of governor is misused. The center is one question which we want to raise. In fact, during the last 8 years, many of the governors, or 2 or 3 governors, were in charge of 2 states. Is there a possibility of people to have be appointed as governor? See, one governor is even now, is in charge of Telangana and Puducherry. So the government of India chooses people who will be bound by them, who will be controlled by them, and who will listen to their words, and post them as governor. This is not the governor's deeds. One question. Secondly, government of India, how they make use of the governors, they influence the governors is the second question. So the post of governor has become is not a it is a constitutional post, but it is subservient to the government which is at the center. Is not acceptable. They should act according to the constitution. They should not act according to the wishes of the union government. That is what is happening nowadays. That is what we are challenging also. We are against the governor's post.
Yeah. Fine.
Most of the time, the governor's post was misused by the government of India.
I think Gaga wants to make a point. Yeah, please, quickly.
Yeah, very quickly. So in 1967, C.N. Annadurai and the Tamil Nadu Assembly under his leadership had changed the name of the state from Madras to Tamil Nadu. It was a historic moment. And of course, the center had acquiesced to it. The fact that the Bengal Assembly, the Bangla Assembly, has again, through a stupendous majority, has recommended this name to the union, and the union is sitting on it. The fact that R.N. Ravi can sit on the NEET Act, the fact that the residuary powers, etc., are with the union, and that is also a hangover from the 1935 Act. So we are talking about a deeper and larger problem here. These powers have been with the union because. So the whole idea is that Indian Union should not be like British India.
Right. I get your point, but look, I must clarify here. In the Constitution, there is perhaps nothing that the governor has a time period that he should respond within that.
No, exactly.
So that's an issue. Yeah.
No, exactly. That's what I'm saying. The reason that there is no time period is because the British also never intended any time period. The British never intended to scrap away. Wanted a provision like 356. So in a sense, we should be the Indian Union.
Right. I think DMK has taken that issue to the parliament. In one of their honorable members has raised the issue in Lok Sabha, I think. or Rajya Sabha. Yeah, they have raised the issue in Rajya Sabha, saying that the rule should be brought in where if a bill is sent or a query is raised, a bill is sent to the governor, there should be a time-bound
And see,
reply.
very briefly, certain points have been raised here. Okay, see, if something barks like a dog, if it runs like a dog, if it bites like a dog, it is a dog. As simple as that. So whether you have a politician there or a retired somebody or an eminent person, it is actually the powers that they have at their mercy. I mean, also examples have been given with America, etc. See, America is a monolingual country. India is a much diverse country. If anything, our state autonomy should be way more than America rather than less. It's something to be. And also, when we talk about the initial years and the unity and integrity of the Indian Union, and those issues were raised by Mr. P.D.T. Achari. If we look at the post-decolonization period of the world, it is overreach of a certain center which or its transformation into an imperial center that has threatened unity of various nations. A stability of a marriage is not ensured by right to domestic violence in special cases. It is ensured by mutual respect.
Right. That point is taken. Well taken. I think Rajesh, you want to say something here?
I completely agree with Mr. P.D.T. Achari regarding his point that the politicization of Rajbhavans has created the problem. And the question is why this politicization is happening. This is happening because governors are being appointed by the central government and they are being selected on political considerations, and they are supposed to act as the agents of not merely the central government, of the party which is at the center. I'm not talking about recent incidents alone. This has been happening in the last few decades. That is why Sarkaria Commission has clearly recommended that a person from the ruling party at the center should not be appointed as the governor of the state ruled by another party. So this is the recommendation of the Sarkaria Commission. And another issue is that.
So what about the issue of checks and balances?
Pardon?
Issue of check and balances. If it's the same party which you're saying, so sorry if I got you right on this. You're saying that one of the recommendations of Sarkari Commission that when a governor is appointed, it should be seen that it should be of the same party. Is that what you said?
No. The opposite.
Opposite, okay.
And secondly, the Supreme Court. Let me quote the Hargobind versus Raghukul Tilak, AR 1979. The Supreme Court says his appointment by the Union government and holding of his tenure on the pleasure of the president should not be interpreted to equate his position with an employee of the Union of India. Supreme Court was forced to say this. So this is the real issue. The crux lies here. The governors are being appointed by the central government, and these governors act at the behest of central government, mostly with political motives. So this is the real issue. That is why we are saying that the post of governor after 75 years of independence is unnecessary.
Okay.
Now there is no relevance for this post. If at all this post has to be retained, let there be clear norms for the appointment and for a fixed tenure, and clear demarcation of the powers of the governor and his limitations.
Right. I'll take you as a concluding remark because we are only 5 minutes into, we'll be concluding. Quickly, I think, Tathagata sir, you want to say? Yeah, quickly. I think a lot of issues, but if you can wrap up quickly.
Absolutely. This is the entire line of arguments that we have heard so far, very erudite and very informed arguments. They bring us back to the point that was very correctly emphasized by Sri P.D.T. Achari, that Article 355. without there being in the institution of the governor, how is Article 355 going to be implemented? How is the central government going to ensure that the administration of every state is carried on with in accordance with the constitution? And I have also said that the Supreme Court decided, a 5-judge bench decided that in the case of B.K. Kapoor, that the will of the people is of course supreme, but it is subservient to the constitution. So these two put together puts us in a position whereby the institution of the governor is absolutely inevitable. There is no, I mean, there could be changes, as Mr. Yelangovan was suggesting, there could be changes, there could be, we can put in a clause here and a clause there. But fundamentally, if we come back to the question of should the question of a post of governor be scrapped, the answer can only be in the negative. And just incidentally, one thing that I think the Nabam Rebia case has been cited by someone. Just incidentally, when the Nabam Rebia judgment was announced, I happened to be the governor of Arunachal Pradesh in additional charge.
Right.
That is just incidental.
Okay. Basically, it was more about the one point which came out of that case is that I think discussion convening the assembly session. I think it was on that.
That's right. The location will be
right. Okay, fine. I take this as your concluding remark. Mr. Yelangovan.
Yeah, I have only one point to make, importantly, because the governor can dissolve the state assembly if it goes, it's not acting according to the constitution. There can be an impeachment on a Supreme Court judge, but there is no provision for impeachment of governors who had violated the constitutional provisions. At least, if the state feels that the governor is not acting according to the constitution, he can make a complaint to the president. The president can study that, and he can even remove or replace the governor. So that provision at least should be there.
Right.
On the basis of the recommendation of the state administration, state government. At least that should be added to the constitution. At least then the governor will act as per the constitution.
Okay, thank you. Garga, quickly.
Yeah, a particularly worrisome aspect of something which might hold in future, and I would like to flag it, which was not present in 1947. So post 1947, we have had linguistic states, but we never had a party which bases a union government ruling party, which largely bases its power on a particular linguistic group. Okay, and that is a very important part of our mutual cooperation and coexistence. Given with the rise of the BJP, with a very large part of its power base coming from the quote-unquote Hindi belt, with the kind of looming 2026 seat redistribution, I wonder what will happen to the post of the governor and its use. Will it be looked upon as non-Hindi people, as kind of people appointed by Hindi people? I would not think we should not go down that line. That's what I think.
I don't think that's currently an issue here.
Post 2026, it is a very likely issue given BJP's support base.
Okay, that's we still have to cover that.
It's not a political debate.
Yeah,
it's not a political debate.
Yeah, right. Quickly, Acharya, if you can say last point, we're finishing now. Time is over.
Thank you. Thank you, Srinivasan. Actually, the governor takes oath to protect, preserve, and preserve the constitution. Therefore, suppose the governor does an act which amounts to a violation of the constitution, then what happens? A governor should never do that. Violation of the constitution by a constitutional authority is something which is far more serious. Therefore, such occasions should not arise, and the governor should realize that they are not personally responsible to what the government does, because the elected government is responsible for what they do, not governor. That is the thing. So governor certainly acts on the aid and advice of the Council of Ministers, but governor is not personally responsible for whatever. That is why the governor reads the address which is prepared by the
Right.
and even if the governor disagrees with many of the things which are said there, but the governor is is required to read it, because that is how the system works.
Okay.
Therefore, the governor has to act within the constitution, and the constitutional principles and constitutional morality will have to be adhered to. That is the last thing which I want to
Right, right. It's understood. Now, actually, it's almost like 3-2 here. I think there is a suggestion that should we scrap the governor's post? There is a mixed feeling here. Some people, of course, feel that it should be, because in the current dispensation, the way it is right now, certainly is not desirable. It requires some amendment, some changes. One milestone which was constantly came up is we look at Sarkaria Commission, its recommendation in the appointment, and later the other point which came out constantly is that also how do we look at the constitution and try to balance that the governor acts in a constitutional manner, and therefore most of these controversies are avoided. Thank you very much. I think we can go on and on. It's a debate which is not going to end too soon. It's a pretty vexed issue, but at least I think here we try to understand few issues. So therefore, I thank all my panelists. I'm completely run out of time now. And thank you everyone for being with us this evening. Good night.
Thank you.
Thank you.